At first glance, this case looks like a simple courtroom hearing about a stolen vehicle. But within minutes, it becomes clear the judge isn't convinced by the explanations she's hearing. A 23-year-old defendant claims he panicked after realizing the car he was driving was stolen. His defense says he has no criminal history, he's remorseful, and this was simply a bad decision made while hanging around the wrong people. But the judge is asking a very different question: if you knew the car was stolen, why didn't you just pull over when police tried to stop you? As the hearing unfolds, new details come out about missing items from the vehicle, possible restitution, and whether this young man deserves probation, or a state jail sentence. The tension in this courtroom builds quickly, and the judge's patience starts to wear thin. Let's break down what happens next.
He came in at 11 because he's got multiple messages from his bail bond company telling him that his setting here is 11 today. They've said over the last couple of weeks they've sent him that same message many times. He's been here every time. In the past, on time, and he's, just wants to apologize for being late, but he's just going by what they told him on here.
Okay, so here's my question for you. Did you receive a reset form from this court? You have to have received one because we give resets. And on that reset form, did it say 9 a.m. or 11? It said 9 a.m. So what I can tell you is this court is at 9, and you should know that. Your bondsman is not the judge. Your bondsman is not the court coordinator. Do you understand?
Right here the judge is making something very clear, and it's an important rule in almost every courtroom. Even if a bail bondsman sends reminders or messages about a court date, the official authority always comes from the court itself. The reset document the judge mentioned is the legal notice, and defendants are expected to follow what that document says. From the defense perspective, they're trying to show that Francisco wasn't intentionally disrespecting the court. They're arguing that he relied on repeated messages from the bond company and believed his hearing was scheduled for 11 o'clock. But judges often look at this through a different lens. In the legal system, responsibility ultimately falls on the defendant to verify court orders directly. So even though this moment might seem small, it actually sets the tone for the entire hearing. The judge is already emphasizing personal accountability. And when a judge starts a sentencing hearing by correcting someone about court responsibility, it's usually a sign that they're paying very close attention to every detail that follows.
All right, can I see the packet for sentencing? Are you ready to proceed with sentencing?
I am, Judge.
All right, I need his paperwork for sentencing.
Oh, I'm sorry.
It's on Francisco Alvarado.
Given the underlying facts, there is a victim in this case. It is unauthorized use, but additionally, by the defendant's own admission, he believed the vehicle was stolen and yet proceeded to evade cross county lines. He ended up in Bernie. So because of this judgment, and based on the PSI report, the lack of, I guess, motivation almost, I would just ask that you announce that.
All right. Defense.
Judge, I've read the same pre-sentence report. I don't see any lack of motivation involved. Mr. Alvarado says he wasn't under the influence of anything at the time this happened. He did know the car was stolen, so when he got lit up, as he says, that's when he panicked and took off. He did end up in Kendall County. He's facing the same 2 charges over there for the same incident. And he's been told by his attorney over there that if the case is resolved here with probation, that they will be getting him probation over there as well. That case is set for April 27th, both of those cases. Reading the narrative, he seems to be remorseful as far as I can tell. He says he's extremely regretful. He doesn't have anything in his past. He's got no contact with the criminal justice system before this. He says he was a calm kid and stayed out of the way and did sports in school. And he's, I think, aware that he was probably with the wrong crowd, and he stated that he doesn't want to go back to hanging out with those folks. So we're asking the court to grant his application, given his the fact that he has 0 priors and he is remorseful and he is gonna get, double probation. If you grant him probation, then he'll get probation over there too, so he's gonna have his hands full for a while.
Now we're hearing the defense try to build a picture of who the defendant is outside of this one incident. They're emphasizing that Francisco has no criminal history, that he stayed out of trouble growing up, and that he now regrets the decisions that brought him here. In many sentencing hearings, those factors can play a big role. Courts often consider whether someone is a repeat offender or someone who simply made a terrible first mistake. But here's where things get complicated. Even the defense admits that Francisco knew the car was stolen before he drove it. And when police tried to stop him, instead of pulling over, he panicked and fled, crossing into another county. From a legal perspective, that turns what might have been a simple unauthorized vehicle case into something far more serious. So the judge now has to weigh two competing ideas: a young man with no prior record who claims he panicked, versus someone who knowingly drove a stolen vehicle and attempted to evade law enforcement. And when the judge openly says she's trying to figure out why she shouldn't send him to prison, that's a moment every defendant hopes never to hear.
So we respectfully request that you grant his application for deferred.
How old are you? So here's what I don't understand. And I'm not the judge who accepted the plea. A previous judge accepted the plea, so I'm reading your stipulations. I don't understand why you didn't pull over. That's what I don't understand.
So I think all he says in the PSI about that judge is that he panicked.
Well, I mean,
I guess he knows he's stolen a stolen car, and he's not, I don't mean any disrespect, Judge, but he's not the first person to panic and take off,
well, I mean,
Yeah.
but I don't understand. He's saying, or at least he's saying through you, that he was hanging around with the wrong crowd, which, if I were talking to other people, they would say they were hanging around the wrong crowd and you're part of the wrong crowd. This is what I don't understand. I don't understand. One, you're saying you don't know the vehicle is stolen. At least that's what your attorney is saying.
No, Judge, that's not at all what I'm saying.
Oh.
He did know that it was stolen. That's the state also.
Okay, so he knew the vehicle was stolen. And
That's why he panicked.
I don't understand why I should follow this agreement. I mean, not follow the agreement, but I don't understand why I shouldn't send him to prison. That's what I'm trying to wrap my head around. So I want, if there's anything else, defense, that you wish to say, I'm here to hear it.
Well, I mean, Judge, other than what I've already said, this is his first contact with the criminal justice system. I know that we don't always give people the chance for probation on the first go-around, but luckily no one got hurt in this affair. Like I said, he's going to have his hands full. If you give him probation, he's going to get probation in Kendall County, and he's going to be under supervision at two different courts at once. I don't think there's going to be a problem with him. He's been here every court setting. He's been completely respectful to me all the time. He's calm, and this manner that you see here is his normal manner. As far as I know, he's been completely compliant and cooperative with me in any requests that I've made. I just don't think that you're going to have any problem with him if you grant him an application.
All right, I'll think about it. I'll have y'all come back at 1:30. All right, who's next? Yes, ma'am.
Judge, may he be released in the meantime?
No.
Much later.
On Mr.
Alvarado?
Alvarado, I'm going to keep the judge's warrant in place. I'm going to bring him back on Monday, and I'm going to make a decision on whether or not I'm going to grant his application. I think it's best, because that's one that I want to think about.
Okay.
And then, so he'll be back on Monday.
Much later.
A terrible mistake and something that I will never come back to, and I just hope after this I can get my life back on track and continue on what I was doing. Is I live and learn, and I will not go back to anything I did.
Any questions?
No, Judge.
All right. I have a question if there's no objection.
Sure, Judge, go ahead.
All right, from State's Exhibit number 1, it appears, oh, this is
That's the right one?
No, this has Courtney Price on it.
So that's the other
I don't
girl over
believe
there?
we tendered any exhibits.
No, yes, yes, I was,
Oh, yeah.
Only
Oh, that's
their
right. It
stipulation,
wasn't the
but
plea, that's right.
okay, I'm sorry. It's okay, I was like, I thought my steel trap was failing me because I was like, I can't remember, maybe I'm wrong.
And Judge, just, Mr. Alvarado's parents are here in the courtroom and his support of him. I've spoken with them as well. They've said they've never had a bit of trouble from Francisco before this. And, they're very out of character for him, and he's told me the same thing. And as I told you the other day, he's been nothing but respectful. And other than showing up at 11 the other day because he got multiple messages from his bondsman telling him so, he's been here at 9 o'clock every other time. And we really asked the court to grant his application for deferred.
All right, I do have some questions. Where are the items that were in the vehicle?
Where are the items?
Mm-hmm.
Of what items?
The person's grandfather's ashes.
I didn't touch any of that. Everything that was in the car was left in the car.
So who took items from the vehicle?
I didn't, Your Honor. I didn't touch anything. Everything that was in the car was left in the car. So.
All right, how did you obtain this vehicle?
We had got it, one of my buddies did, and I ended up with the keys and just ended up joyriding it.
No. I mean, you're skipping over some things. Counsel, do you want to ask some questions about that? Like how he ended up with this vehicle? Because with regards to the PSI, they're saying some sentimental things are missing. And I'm trying to figure out where these items that were in the vehicle.
Where did this happen? Where did you see the vehicle first?
I seen it here in San Antonio.
Well, I don't mean that. I mean, be more specific. Where?
One of my friends had it.
Okay. He brought it to your house? You went to his house? What?
Yeah, he brought it to my house.
Okay. And then you ended up driving from there? Or
Yeah, he ended up giving me the keys and I ended up driving it after that.
did you inspect the contents of the car at that time?
I did not.
Okay, so before your friend brought it over there, who is this friend? What's his name?
Jaden?
Okay. Before Jaden brought it over there, possible that some things in the car may have been taken by him?
As far as like ashes and all that, I don't think he would touch any of that, but I know I didn't grab any of that.
Well, I mean, when you got the car, did you immediately get in and start driving?
I did.
Okay, and how long was it after that the police tried to pull you over?
Like 30 minutes.
Okay, but you'd been driving the entire time?
Yeah.
You didn't stop anywhere?
No.
You didn't stop to open doors or look in the trunk or anything like that? So you're just driving around and around? Okay. And once you were pulled over, you no longer had anything to do with the vehicle at that point, is that right? When you were being pulled over, do you know if you or your friend Jaden or anybody else that may have been in the car was throwing things out the window? Or? Yeah. And I don't think there's any evidence of that, Judge, either, but just thought I'd ask.
Any questions?
Yeah.
All right. So let me just tell you, you said that these are, you made a mistake. No, these are choices. You understand? These are not mistakes. These are choices you made, and that's why you are here. How old are you?
23.
So this person says that the total amount that they're able to account for is $5,000.
Or I haven't seen anything about restitution, Judge, but I'm glad to have a hearing or inspect the.
I mean, they're asking for $5,000 restitution. So, is there going to be any objection to that $5,000 restitution?
No, Judge.
The court is going to find you guilty. The court is going to sentence you to 2 years in the state jail facility. State, unless there's anything else, you may be excused.
Thank you, Judge.
Thank you.
This final decision shows just how seriously judges take the chain of choices that lead to a crime. Earlier in the hearing, the defense tried to frame this as a moment of panic by a young man who simply made a bad decision. But the judge made it clear that in her view, these weren't just mistakes, they were deliberate choices. Choosing to drive a stolen vehicle, choosing not to stop when police tried to pull him over, and choosing to involve himself with the situation in the first place. The court also considered the victim's reported losses, which included items totaling about $5,000 in restitution. In criminal cases like this, restitution is designed to compensate victims for financial damage connected to the crime. Ultimately, the judge finds Francisco guilty and sentences him to 2 years in a state jail facility, a decision that reflects the seriousness of the offense and the risks created by fleeing from police. Now we want to hear from you. Do you think the judge made the right call here, or should the defendant have been given probation for a first offense? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.